summary trial. Despite the aforementioned, the bill did not respond to the orders and recommendations of the Constitutional Appeal number 2 of 2021 Attorney General versus Michael Kabazaruka as far as independence and impartiality is concerned. Colleagues, I am persuaded to take you further to our next point of dissent, appreciating that you have read what we are talking about. Colleagues, I have seen the labor you've had to listen to these submissions because it is aided by legal gymnastics and quoting of cases. But please listen. Let me go to recommendations. Recommendations. The minority finds that the provisions of clauses 30 specifically proposes section 117A, proposed section 117A is unconstitutional, irregular, and illegal as far as it allows the trial of civilians by military courts in the circumstances that are not exceptional. B, it extends to the jurisdiction of military courts. It extends the jurisdiction of military courts to the entire civilian population and to all offenses which ordinary courts are in position to try. C, the bill also extends military courts to cases reserved for specialized courts such as the High Court. The bill extends service offenses to civilians. Minority cautions Parliament to use them the UPDF, where therefore recommend that the same be rejected. 4.0, lack of public participation. The Constitution in Article 38, 1 and 2 thereof reaffirms the right of everyone to participate in a fair in the plenary, which started at 2 p.m. The requirement of public participation is rooted and entrenched in our constitutional framework and must not be cosmetic reasons. Colleagues, various stakeholders were therefore locked out of the process due to this clearly cosmetic semblance. In the view of the minority, this did not meet the required standard of public participation. Indeed, apart from the Attorney General and the sponsoring minister, the committee interacted with only two other stakeholders, that is the DPP and Council Jude Biamukama. One would wonder why a matter of great national importance of this magnitude would only attract two external stakeholders. This is unprecedented in matters of this nature. On this account, in addition to other reasons given, the minority invites Parliament to reject the bill to the extent proposed herein. This was the conclusion of the minority. Right Honourable Speaker, whereas reforms within the UPDF Act are necessary to address contemporary security challenges. Such reforms must not compromise constitutional rights. Judicial independence or civilian oversight. We, the minority, persuade this Parliament to reconsider the provisions of the UPDF Amendment Bill 2025 to ensure they align to the principles of democracy, rule of law, and respect of human rights. Therefore, the minority unanimously are of the opinion that the General Court-Martial and other courts do not have constitutional jurisdiction to try civilians or adjudicate non-disciplinary criminal offenses, even if committed by members of the Uganda People's Defence Force under Article 210 of the 1995 Constitution. Parliament's power to legislate for military courts is strictly confined to matters of discipline and removal of the UPDF. Members, military courts are therefore internal discipline bodies, not general criminal courts. Write the constitutional mandate that all criminal justice, including a fair trial right under Article 28 and 44, lies with the courts of judicature.
Thank you.
Members, this was jointly and severally the report by the minority. Back to submit.
Thank you. Thank you so much.